Enia, Boko.
Ekoye.
Yeah, once you are Konya Hondi, yeah, Nanso bond, Ankra for
bond and seminar, yeah,
and hard, you die, and
I can see that. Now, negotiations with finance minister, I was saying,
I said, see, finance minister, Wama ye GDI will Nimuna cock, because on say. Or saying,
Bopa, closer to the microphone, Kakra.
Finance Minister, Wama, ye GDA on the moon article, because on say Friday, 27th January, or saying, boss say, bonds, no, a drew super, a buying between and cat. Monday, 30th January, so I AC SRK, it's in Daily Graphic.
Okay.
Afe, the following Monday, 6th February, Monday, yeah, Abesunque, just Monday, Tuesday, Wednesday, no Wednesday. I do say omuntua bonds ni bia wentua if he say a delay or an employ say the be amanfo bebo hu na omo akọ sign say omo pe aban new bonds no if he say finance minister ne aban omo amfa kwan papa so on say wa share board that say bonds na say we say pese obey ode bonds be ba beje foforo. That's in other words pese obe participate. You know, it's okay enya hwe say what dey na drew so aban betua oka nti na Monday 6th February payday na was aban tua about 4.2 billion 4.2 billion yes
Ghana cedis.
Yes enye nyina na ye ankra for individual bond holders na dia e be banks
near
ba ya keka ho no at least anka e bia bibi kura e bi say e bia operationally if you say on the banks no agreement nti afi na opese sika no otenase na o segregate na say banks nie ankra for nie o ba no ento asum ye nyesa o say nipa wa hye embo if near amanfo ka say enu nti no ntu aka no if that is the reason at least for official statement bre and I interviewer 2 minutes be in the finance minister and Kasai or married. They don't have to talk to us. Official statement, you don't even have to talk. You just do. Your secretaries will do a letter. No one sign it. That's good governance. Or my man for na. But
Enra pensioners or most individual bondholders, no echo finance ministry. And I saw him speaking to them. Only Eddie.
I said, Nina, you know, on Timin Casa payday is so February also.
Never say Utriano.
And the enumerate and the enumerate or address here, no, right?
Yeah, Enra, yes. No, I think 3 days ago.
I say enumerate. Still, I want to have them. Oh, they be a finance means unjai. Euro for that unjai.
But doesn't it also go to prove ABI indeed they are in that street? Nioma Yedi and Casa.
David Obi Antisa cry Obi Obekasa me say Fikasamu you can say scaremongering.
Okay.
Or man a man for a book who can scaremongering. Look, Obi if you don't need to be an economist. Normal sense, you cry in your economists, you can kind budget, and you who say, now say a few a buying person 227 billion, and winting a buying person or your debt exchange in the account. It is a man for a mobile busian, so almost say, yen to me and more busian beyond. And yes, share also okay, and a Jusica, and Tim Puntu Jumani bin I was say at Tisso.
Not at Tisso.
So it's just common sense. Obia a chile economist, a big room or Munina Peniso, I Peniso, Institute of Fiscal Studies, Ebia and board Dr. John Quachi, or Mark Peniso, Professor Bodwin, Dr. Mark Esibe Bua, former chairman of the Finance Committee, Parliament, Peniso, all the top economists, Professor Peter Corti, Omunina, Omaji to say yes, reducing. Cutting expenditure and now for fiscal adjustment, technical almost yes, it's one of the ways. And it happening why? Because Obi said, Sasike in Sihuno, and the editor no, and the editor Danka, and the editor school fees in the account. Yes, it's Canada. They be near mature. So February Monday 3 days ago na finance minister on country e panacho ombra me confirm say o this can ban tentema enye yes mane ya mambo
but more expect here no because in negotiations with him no was suspended the IDS anka 2023 ebe zero payment no ma suspend here no.
Yes but you see let's repeat OBS says our program enye show Opa na obe sign
Sure.
Ompa.
Sure.
Nti se see oh yes from 0 no about 10%.
Okay.
And a bondholder so mumpe. They say mpe with the dada na ekura no.
And no one more there. That's what you signed on to
Yes,
initially.
yes, we don't want
no one
because, and the reason is that new ones no okojia you are losing about 60 to 88% of the value. Once inflation in your market car say bonds no nti mpe nti pa ban cho say it's not a good thing because it's an amount for na but still when you kukudura or man sign it but it's not good it's bad governance amamu boni and yes rough tactics I had to say rough tactics communist inferior tactics bisa no and yet you more mind sir hey no man penye ya also kai say man penye ko gina wiemu ne eto man no ko gina wiemu we are bossy so man penye kufuado oba it stood in the sun and now kitua ye nya no abro no only finance me so my ye say chom when ye sika bonds here dey asem abre no and no na ma omo ye data bank commission data bank ye for your time man penya ye
but so man penya nye shareholder o data
they be na send the ebusia na scan ko ebusia mu hey obi debi sanse ya menka listen obiajitu na for your time scan nye ebusia mu na
o na say ko ebusia mu no nje so man penya
o man penya ka ebusia na visa nka no nka wanka o man penya ye for your
it is ka bia obenya from your law practice we busu nyina ye is that what you mean
na say me ye my busia ye na me me wa fa se me bi to school fees me mo musika ne na account that's how it works and so man penya ye na on kan se ko gina wie mu ne eto ma no nti ne aketua ye nya no ye kakra ye bedin eno kra no mo gie free ensem e de akotwa akwan so that you can break the 8 or there be you move mind sir no article 36 clause 1 is very clear onokra article 36 then say aban emma ye duane
Asempa FM
I say aban emma ye duane ndi ba we ye mesra aban say aban ma ye duane na yanke say we sika kakra bi a ye de aba bo aban bosia a ye je nsi hu no ene ye de hwe ye ho anu so a si keni me fa mamo me pese me ye na me ho ha me kwakotwa akwan ukum nipa akotwa
akwan
I mean how who does that
but you know finance minister catch pensioners ne say omomo aban na aban so emo
debi obi atro ye nkanesa na ye ka no ukum nipa edisika na kwakotwa akwan when you kill your citizens if you don't have citizens you don't have a country
you don't have a country
you don't have citizens you don't have a country onto no body America afi moma ye ho akire no this year we are going to spend more than last year the budget is increased you be 227 billion 227 obia peniso say ankra for yesika ni nyina ye 15.5 billion fa yesika mayen we so di asem ana nyani nyina so na be mature this year nyani nyina na
the ones na be mature this year there
for my next year so sa obia kan si dey cake ompini aden me say professors no mu nyina peniso say fiscal adjustment is also a way of dealing with our problem fiscal adjustment in plain say cut expenditure
on some other areas
yes it's all come on you don't need to be an economist nya na ya de bia omo kire enkwara bremu cut your coat according to your word cloth
and your cloth
nti o cloth no sha live within it o chinchim amanfo nsa wa gisika de kwakotwa akwan ye wu a I mean how who does that anyway
but lawyer nti ye be pemre na yakọ enomu ankasa ba enne no enano enna ye didn't come to studio that was on Monday and we were told say the other party then so no interested say almost be Ghana for ate almost side of the story and when we engaged we were told say one our empire builders lawyer CCR na unim efa story we hu we are told say it's traveled through the court system in Ghana could do Supreme Court. I'm a ruling in 2020. Say defendants no ena edibem. But omuntimi nya peaceful enjoyment of omasasi I was say omunya. What's happening? Asama.
Obi. I don't know. You know that woman meet a Monday near a Topkins by Eura who say chap. Omo interview near Assembly Tisa crack.
On different story.
Yes. Meet as I say, oh, now opinion I don't know better because when you say by me Trasacco so by become asem. Judgments in there had me read a na meet audio into some of the judgments no by us.
Yeah, we have copies.
Me candidate announce so I should say be one. Okay, yes, ampa assembly say could do a Supreme Court in India ampa no from High Court. High Court buya assembly 2003.
Sure.
June 11, 2003.
Sure.
So from Hono a Trasacco Ampene so into that's Empire Court of Appeal. The Court of Appeal 2014 and the court Supreme Court.
Yes.
It is Supreme Court and so 16 December 2020 no my judgment.
Sure.
Tiamra Obi assembly ntisa let me first give a summary. Asana ya pointy. Ne woman ni say Empire Topkins omunya 62 acres per 62. No mo 62 no Empire are popularly are Fred Trasacco. On fan the 9 could see ho. So the plain truth in say the entire near court and say sa 62 ninety and Empire the assembly court down court in 1999.
Okay.
No say you right who say chan almost 62 acres. Now 62 no say the musinya and say your Topkins ankasa no omo de na 22 acres. But Topkins na abrofu bi you're from a top rate company, real estate. Into Topkins na abrofu no form a joint venture. Into joint venture ni nenya 39.5 and our friend of 40 acres. No? So there's a joint venture. I will now come. I just want to give the flowing story. Answer the chile ni akase share. Into what the Topkins in Kwan Jina 22 and the Topkins ne rate top real estate Jina 40 acres. So they're 39.4 and 40. So 22 plus 40, we need 62. You munya no. Now the entire assembly court, it was over that 62 acres because now Empire say 62 no, and yet Topkins there on any company and there, and no na you call High Court and court and say they be and no a your modia. And yes, no, still I am penny.
And I'm called Court of Appeal.
Court of Appeal, no Court of Appeal said they be Sasas and they are modia. Yes, still I am penny and the Court of Appeal no, and I'm okay be BTI and Kakra. Into no any 62 any you call Supreme Court. Into you call Supreme Court, no 62 in the Trasacco, Uchimutaya. Tia make us a Trasacco Empire. Trasacco is popular in here, but the name is Empire. It's a group, it's Empire nearby.
Yes.
One of the group of company. It's a Supreme Court to say, sir. But the second one you're complaining, it didn't kunimo. You can see Omoko Supreme Court didn't kukua. At that time, I wasn't the lawyer. I was a lawyer, no doso. And to me, kakra, ubinsu kakra, a number of lawyers. Osha judgment, will show. Court of Appeal, Koka say, Yankrata ne cry no. Trasacco Empire Tarikuni or a foreigner foreigner from constitution there and can see a man 50 acres. Echo Supreme Court said debi sa se me menka obi amfa eno ame down nti ye din kunimo ho nti obi a wo se we din kuku ne krata anka Court of Appeal t yes no so ba 50 say or a foreigner no Supreme Court said debi Court of Appeal 18 and Supreme Court restored this said that thing is wrong set aside. Nti si ayembra mu details. Nti 62 ana obi hu Supreme Court judgment na high. Dia na mo ka.
Yeah, but on 62 no. Is it born out of the fact and answer one can be because based on reliefs Modecor Court at the High Court in 1999 and with your permission in the Supreme Court ruling page 2 no kase background by a writ of summons issued on 24th February 1999 the plaintiff commenced this action against the first defendant for the following reliefs. A declaration of title to a parcel of land situate at Ajerigano North, Accra, comprising an approximate area of 456.25 acres, the full description of which were provided in the statement of claim. In the 62, no, Ephraim. Because this is the relief more as plaintiffs, more they call High Court. And society, what High Court, what Court of Appeal, what Supreme Court, it's the same acres we know more can.
Good.
Yes.
So ya ka say we nyina ye dia. Say na omo ha agent 62 19.
Yes.
To omo fale omo nkrata no. No, I'm say there be 62 near there. So I'm even happy you've read it. You see, we'll soon come to it. Into idea Trasacco D can first on we say 465. Ube year no. We say 62 near media. So that's the point. What best 465 actually yes a Sunday about 456. But between 465 and 450 it's just your friend is saying 10 acres.
Yes.
At times a fra more fan chain because sometimes you need to flow. The main thing is that 450 is a number you shouldn't forget. Uba no, ube year no. We say, oh me, Topkins and Casa de me 22 and a media. Joint venture no between Topkins and a rate top no.
Yes.
39.5 and 40. So sometimes I'll call 39.5 or I'll call 40. And no. So by inference, Nipana ba. Empire by I say 465.
Yes.
Oh by year no. I say 465. Many unia sembia media 62. Me name joint venture. Me name abroad no 62 an dia. Sa ane omotwe asem no. Nti Supreme Court judgment and the die page 27. Obehu I say however by an amendment that's paragraph 48. I say however by an amendment it effected in its defense to the action. By an amendment, it effected in its defense to the action.
Yes.
The first defendant averred for the first time
its interest
in 62 acres
of the disputed land it had obtained from the Nungwas tour, which it registered in 1999. According to the plaintiff, the Court of Appeal failed to evaluate the inconsistency in the claim by the first defendant that it acquired its interest in 1993 and the document was executed, blah, blah, blah. But at the end of the day, it says Supreme Court ruling now. Say, or man a judgment based on the reliefs our plaintiff, not the court. And plaintiff no relief, say Supreme Court any declaration say omo title on a cover 456.25 acres and the plaintiff lost that. The Supreme Court did not grant you that.
Before Supreme Court no yanko High Court there na High Court kan High Court say Trasacco did bim, that's empire did bim for the rest of the land apart from 62 no any abind there no into ya omuka meba. And then there was something they said at Court of Appeal meka obi also I do no credit back up mean to me metna hand dia. I will explain to you the idea on person mugina no by is late we they ain't taking one step at a time. Justice Broby I say no specific order, so let's get this means that let's come. That's why I'm reading page 15 High Court judgment.
Of the High Court judgment.
Yes, page 15. Last but one paragraph. Now if you may read the last paragraph, so 3 lines. I say this means that the defendant is to keep the portion of the disputed land that are already in its possession. The defendant, no more does.
Yes.
So later I'll be clarified. Then listen to that. I say to avoid confusion, very important. It is important to clarify the portion of the disputed land where the plaintiff's claim for possession failed. The judge say for avoidance, I mean, Bibia enye Trasacco dear. So 22 acres. This covered the 22 acres, the 8 acres, and the 32 acres of the land in possession of defendant. So I say Hankwana Trasacco e default. So you see it. Yes. You see it, and if you go to Supreme Court, you still see the BR Topkins say, oh, maybe 62 na media. The BR throughout. No, 62 ni. Then baby a Trasacco when saying you been so ya abiding, and then let's go. I say, as well as the land granted to the government in 1940 for animal husbandry and road.
Yes.
Sir, 1940, actually, omo calculations now, nobody is denying it. That land is 114 acres. But Obi Minkan Shemusisia, that 114, no. And Chebia 2010. And now, I buy a ton, sir, assassin my, and we need 114 acres now. I buy Obi. Yes, you need. That this is the lease here. I buy ton my. Now I buy ton, when you buy Trasacco any Nungua fine. Nungua cry you see no hini or Hong Kong hini bibisa something kind of chief. Inti assembly cost war court no na Trasacco ni nungua ye fine nti Trasacco boa mo pa ekwa aban anim say aban form nsase mom nti aban returned about 900 and something acres 950 bro almost 1,000 acres to nungua's too nti all returning no 114 year page 15 High Court say aban do no asase no mo returning no 114 emu fa ekodi ho 62.44 ekodi nungua's too ho but if he say sa asase no ben Trasacco original Trasacco no pa nti say Trasacco na oboa di omanim say aban form asase mom nti as part of that no and omo sign etwa omo ho nyese etwa I mean positively and omo ma Trasacco 62.44 acres enu so enu nie
yeah but the court ruled on that say during the pendency of the suit no untimi fetching ko regularize asase ana wunya ye na afi na akwaje title when the case is in court you can't do that.
Obi, there's no case, there's no judgment like that. It's allowed. Uni obi court udi nkunima. You are allowed to compromise. Ex parte asari.
No, at the time na muni nkunim. Time muko hu nunguafo no to get title to the rest of the land said ye wo kan akwaye nkoso hene ne sa ne ma no. At the time na asem ne wo court meboa.
2010 but then Adenta High Court na ewie.
Na mo di High Court yeah but say High Court na nyamu na mudi nkunim.
High Court ye di nkunim pa obi debi enna meka so obi abeka na oboa obi enu nie yes say 465
sure
yes say hey tete so nti what tete free mu it's about 288 who you see 465 na be chire ye hu say 8 acres bi na nka ho ba wo de sesi e bia ye studio mu nti wo de even bring it down to 278 acres we free we otite 62 no any aban 114 no e free 456 no ma you get about 278 acres yeah there and we ha no I say to avoid confusion Trasacco we enya wo there and they showed nti ano na ne yet so but still na enya Trasacco empire de na enya empire builders they say yakase 62 no ye top kings there nti no kwa appeal and then I bind into a challenge 62 no that's the main thing enti and I court of appeal said the master debi and also your pachara top kings there I bind no there not wearing challenging it that much whatever it is so what take 62 ne free more a free 456 more now what take 114 now you be left about 278
but my point is after Supreme Court no Supreme Court man judgment no na it was say he enforces our judgment there was still an issue
yes
pay police for her call baby our client went to the Adenta High Court no.
Oh yes, I know you too.
Moko Adenta High Court. No, what were your argument? And then I'm going to call Adenta High Court.
Nearby, and I say I wasn't a lawyer in it. We are not running from it. Say judgment. If you say Nasla, meant me who has any yes. Client to call you.
Yes.
Na court say they be Supreme Court. We are some into maybe because say the thing yenti Adenta ne buy and say and if you so be a betiase okay kaya. But then tiase nye juma nti ye high and say omo jiasas no nungu afu be junior you know. And me a call court. So and you say oh I can't tiase because Obi, look, to be very honest with you, me met na ha en ka sembia ochina lawyer fufro ban wa ka say Kpebu abompa de bi menye sa ade no ahia na ebedi ne make no ntina pese me kan nyina no so the truth is that way no say am no ka say soldier for Major General upon pepra what the no crop for aba ho for what a soldier for wo ho no
yes so there is an issue national security is seized with the issue inti omo boss asase ho ban
inti wahu ni inti a court wahu ni inti a
but lawyer the other thing is a call Adenta High Court supposedly no on this same argument say High Court ne ma mo party bi wa ma mo party bi ne ade the Adenta High Court still said say case be anyhow
yes or say for them no court buya so massa go men san me shase because na my pressure because they say nungwa so ombeje say nungwa atro letters akoma homeowners near you say
sure.
There are rules against all those until one say if there is pressure na because okay na court but we know those rules once I don't know by no Mukoti Henderson the rule against that's estopel and there are estopels right court buya assembly that okay, issue estoppel, course of action, and then call. But my pressure, to say, here. Still a soldier for Bigu, a honey, and they saw by one castle, I could face soldier for Bigu assassin. No,
Omoka say national security at a point, ma soldier for
Omoda
assassin.
Omoda may so far just say there were some parts I didn't hear. Who brought them? Topkins now cover soldier for about how? If you read, look, Obi, me Obi. I want to say that after this, if you call neutral lawyers to come and talk, but Obi, unless Abia, but this is I understand them enough. Judgment in the doubt mean to me met now. I say me kwa bibi me ba baby a non person mujina so kase assassinate your mother, and then you see whether that's the truth. That's not it. Obi, let's get this first. Nungua won ye koye no say high court ube hu say baby how kind who say nungua ba ho say omo ji omo asase high court na court ne say dey be nungua untimi nji wa asase. They were thrown out. Nungua was thrown out, and one say the court accepted say assassinate nungua die, but sisiano mo amuka ho na mo de ama Trasacco ene ne keka ho empire it muntimi nji mo asase hwe we have page 4 I say the first and second court, okay, I'm starting from page 3 bottom high court. The first and second court defendants joined this suit on behalf of the Nungua's too. The first court defendant died in the course of the trial, but the suit was continued by the second co-defendant, who in fact testified on behalf of the Nunguas too as the DW2. They claimed that the disputed land was part of Nunguas 2 land, and therefore challenged the title of plaintiff's lessor to them. The two pleaded fraud against the plaintiff and finally counterclaimed for almost say court in here declaration of title of all that piece or parcel of land situated and lying blah 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 Jiringano and not Wakano. Cancellation of the statutory declaration as having been obtained by fraud. An order for recovery. Recovery of possession. Not just say G assassi. Obi Okan could do enda. Court said there be ultimate G assassi. Obi, that is it. Me this is it. Say why we have you seen it? Page 4. I say me G assassi nungua ba court say masa ye G assassi. Court said there be ultimate G assassi no. Court say ultimate G. Yeah, man, into one plot cry, court and manunguas too. You know, we are fine, I'm not saying it's
and this is at the High Court.
Yes. So we are going to maybe no crano. So let's go straight to Court of Appeal. So Obi, what happened in the Court of Appeal? Any near on Piso Mujina. Abra, into what we say an order for recovery of possession, no? Right? Trasacco and Sokoya amendment say ope order for recovery ope se oje assassino order for possession aban court man possession no order. I don't know if you have the Court of Appeal judgment or maybe coming in
appeal court
and no that will left that's no okay so that I can point whilst we talk order for possession in the Court of Appeal near High Court Judge Justice Bobe Maye now or say everybody should stay on what they have. Into Obi, Cecilia, and also to clarify before we go back to the Court of Appeal, let's make something very simple. Yes, sir, sometimes we can complicate that. Yes, see, after Bro Beka say Obi endi ni lemu, why baby I will develop it and I will assume no. Obi endi ni lemu, just stay there no. And they call 62 for Topkins and the company no. Then 114 for a buying, and I make us OT3 more by default. You'll be left with 278. Then Court Trasacco. And no Obi endi ni lane muno. Right? And now Trasacco say there be me pe order me call appeal. Until appeal court could do na Court of Appeal say o Trasacco onim empire there be High Court no. Na ni kwan say obema order for possession. Yes, let's say but it has a context. Na ni kwan say obema because what day krata buy say o pese o sesa wa no na oje recovery no. Court ne ma kwan no one diso on say to say o the asem court ya typographical errors ne nyema unto better amendment and now we refi bibi into which make us me person me di bibi ka ho na court ma kwan say okay ko faka ho possession no but ye were like 2 weeks anti empire nti me anya no within that time nti na court ne say wo no ye ma wo kwan say ko amend na chese ko sesa wa no na ka say open possession no wa anya no within 2 weeks nti wa anya no within 2 weeks ya once at the time now we na time na pa ho no and ni kwan say court ne be ma wo your friend is saying possession. And I may say so obi there is this principle saying TTO. We see it at page 16 or 15. Let's start with 15 to 16 of Court of Appeal, or say 15 down. The fifth ground of appeal was on the trial judge dismissing plaintiff appellant's claim for declaration of title, yet ruling that the plaintiff was entitled to possess other lands not claimed by defendant respondents. We notice from the record of proceedings that on 27th March 2001, the plaintiff appellant was granted leave to amend her claims to include a claim for possession. My concept for possession, not just near what top case new. The amended writ of summons was, however, filed on 23rd January 2002. Blah 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 blah. So he say, since the personal notice was not filed within 14 days, the leave became void ipso facto, meaning there was no claim for possession to enable the trial judge to make any order for possession in favor of plaintiff appellant. Until no cause so blah 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 blah. So that is the one. No say or order for possession. No assassinate free your friends top kings. That's what the possession. No, I said no. So intina or say there was no meaning there was no claim for possession to enable the trial judge make any order for possession in favor of plaintiff appellant. And the plaintiff appellant in this case here, Empire Builders. Yes. Into the request for possession, the court non granted. The court did not grant. Yes. So Court of Appeal said null and void. Now let's come here, Obi. And those were affirmed by the Supreme Court. Yes. It means anything that has got to do with the land, Empire Builders should not be on that land at all. They be that's where some can say a bit correct. So let's approach it with the Bisa lawyers. Court, so far Brobe say Obiandi ni lane, baby I was some be a keep. That's what Brobe said. That's Justice Brobe at that time High Court, the Jones or Supreme Court. Yes. I see everything, and he's still alive. Good. I see everything. Everybody should keep what they are already in possession of or developing. Yes. Now, Court of Appeal say, Daukra, you can't say koye, one yet, inti, and you can say, Yebemau is void. But, Obi, any panel that hoti assassin, so bisa lawyer or your land law, land law power, say law, no, your different areas, inti lawyer, what being or land law. Now, Satan near the assassin, so. Into Obi can Court of Appeal after saying the thing is void. The next thing is that Okase Nungua Koji Wasasi. Okase Nungua Koji Wasasi. They be Okase Topkins Okra also pay 62 62 Ukraine and Kayano Media Chow. They be no, but the court also affirmed say assassinating a teshi stu nedia a nungwa for there. Yes. You agree with that? Yes. Oh, so no from High Court, High Court. Won't say nungwa for there. And before say mo file suit no at the High Court in 1999. At the time, na mo assassin na mo claim say mo to free teshi for her no. Yes. Oh, yeah, jitumu echire na ehun say K they are wrong. Wrong. Enti ye ko nungwa ho 1999 to be say Supreme Court omo kan MOU be first ye di kan koye MOU. Yes. Echire case no cost no 2006 and ye ko give confirmatory deed ni nyina ye tue sika and then echire you see another. Yeah, but ehona na me ibusa say time monsa kan sa mo confirmatory deed and all of that no. Na asem no e High Court. Oh yes, good. Na no by confirmatory deed 2006 na Court of Appeal. Na Court of Appeal. Good. But that period in na injunction that assassin so a obi antimi nkoso mebo. There be I say bro be wie no. I say echire that injunction na hard dwen ye. Nti omu yi free ho. Nti na Justice bro be wie High Court no at that time when he was a High Court judge. Yes. No I say listen, so he sat down as Supreme Court judge. So not a Supreme Court judge, but he was asked to sit in the High Court at that time, 2003. Yes. Or say everybody should keep. I don't know yet can or say everybody should keep. Until you can't keep you continue developing. Until you injunction no crazy ho. So everybody should develop. So the thing is this, let's repeat. But the time Court of Appeal because this thing is void, no. Yet see Satan is a notorious fact. 2014. By then, now, your friend said 18 December 2014. But Trasacco we see a man for titi ho. Until ya obeti a free case be in Ria Shalibotwe Stool Affairs, Ajeti Abusu, okay, 2003, 2004, the same Supreme Court. I'm say, oh, Uncrofor more Mosisi or more Diana. I was assassin, be swa, assassin, so you're trim woman soon. One for man, Macota, would decase Nivea, went to me Kobu, internet is Uncrofor Motitusono, accrued rights, third parties. Internet, I say, into would Obi, son, no, working kind, into after Court of Appeal, said the thing is void, no. What is a court take say Nungwa Kwaji assassin, Nungwa Crank Casa said by then 2014. No himself was signed confirmatory deed. 2014. No himself was signed my deed of assignment. Okay, I bind the no. Yeah, the man Nunguano. Yeah, and then look at the dates 2010. Nti Sheni na say we you see all of them.
Yeah. But say Nungwa to me about on to me Kwaji assassin, meaning assassin na already no developed that no. And no own to me, my major assassin. But the ones now, bear now, the main subject for the litigation and so.
Obi, menjin to Musaba, let me answer it the way you want so that we'll see quickly.
Okay.
Near bear will come so that even makes it simpler. Yeah. But we'll come to the other argument, but just answering simply. Near also I bear no. By 2010, and I'm making a assignment between Nungwas 2 and Empire's builders. Enunye.
Yes.
What peninsula atonga my this 62.44. Near air bed at that time. And I say I buy 114 no. Yes. I say High Court judgment was in 2003. So 2009, 2010 top Empire AD when him say I buy 4 masses more. They got about 1,000 acres. And I say 900 something. But to make it easier to remember, no, of 1,000 now. Yes. It's rounding up. Yes. Not that we don't know the figure. But mention a figure that's easy to remember. So we are rounding up to 1,000. You see, but then no, you are more 1,000 acres. And now, as I see we are here, humans, a vehicle raho. And now Nungwa sign yes, say, oh, J, you amount 62 point acres. So that is it. And only book no lie. I made the buy book no lie. I'm buy I'm the trail. Maybe Obi Intina me say Kai said, me say I say my make me person me sorry now friend lawyer or your experience or ba it can be different. Land law. Oh, master, okay, land cases are here, why cases are here to be sure, say we deal land cases, Akko Supreme Court, so that you'll be sure. And that way, Assassin High Court car say animal husbandry make Ubia Peninsula say Ukususua is about 114. And no na that's 2003 judgment. Inti by 2010 no. Aban Eddie or Masasi Momo. And na Nungua say, oh, what's the Trasacco so pesa see? Okay, 62.44 BD ho. Oh, into Trasacco J say no one. Ya boku si atafre okra wo ye nkoso hene e wo ha ne ne ntije 62 enunye na wo he enu na sisi na asojafo abaso no this Nungwa signature mpenyi from signatures ni.
Yeah, but do you know say even before say ye beba after this whole judgment from the court, no, were you given right of possession to that land?
That's what the people are saying, you know. After no, maybe you can see right of possession. It's in the judgment, so it's within the same judgment. Abai say, sir, you know,
yes.
Justice Brobe say, yes. Everybody stay. The right of possession was given to government of Ghana, and no beyond government of Ghana. Dima Nungwa part of it 114. No, government kept 57 acres and gave 62 as part of the 1,000 acres they were giving back. No, intisana yeah the man. So in the judgment, simple answer yes. They said government keep the animal husbandry and road. Government keep it. Until after judgment, Abaya Jinkunim. That was not what Top Kings was. They say even if they were appealing it. Sorry, that was not what Empire was appealing. Even if they were appealing, the government is won. So government turned around and gave 62 to Nungwa. And then Nungwa turned around and gave it to Top Empire. And the remaining 57 point something, no. Then the government gave to Empire directly, and also has made the Naba. So, see, baby and Tokano. So, into Obi, there was this question you asked that possession. So, let's just simplify. Into idea, what sign it? A friend is saying agreement. Eddie, Assassino, Amma, a friend is saying Empire. Oh, yes, saying Saba said they be OJ. nti eno ni hwe aban so
eno ye nunguafo no asen aba ho so omoje. That's what you mean. But why are you not taking them to court? In the other na momfa nunguafo no court.
Say eno na see the way it's going no. We'll look at it. As we are explaining here, perhaps sometimes once a court, once we know 20 something years.
Yes.
Sometimes it delays. We'll look at it. We are still reviewing.
Yeah, because until you go back to court, as you did in the attempt to make Adenta High Court. And a court said Debbie. And for now, no. For Topkins, the understanding of the ruling, High Court, Court of Appeal to Supreme Court, no, they think it is in their favor and they deserve to be on the land. Because I must say Supreme Court no is ruled for them.
Obi.
In the most ceremony you have to go back to court.
Obi, no? Before you repeat, say working can judge. Bibia was even a hakra for the first time. Topkins said we have 62 acres. It is even Supreme Court judgment. 62. Oba ultimate catcher say 62 nimu na Trasacco empire ba. Where the problem is right now is abain 114 na abain there Justice Brobe say abain de no na ebikodi nungua ho nungua ton ma empire na ne edi abain ho 57 point something no so abain ton ma empire no
but the point ne say the 450 something now what they call court as part of more claims are making at the High Court 99. That was not granted you. Because more say you declare some more title to that land.
Yes.
The court did not grant it to you.
Yes, if they don't grant the balance, want to say Justice Brobe say, hey, side there, not just say Udi Bim on the rest of the land, but see to avoid confusion, men caught this other side. And Obi, the way
that what do you mean they beam on the rest of the land? If say a 4, 5, 6 now the court. And the court don't do that. Don't do that. No, so me busa question and then you answer. Yes. O the 4, 5, 6 and the court generally. Say court declare say what title to that land. And the court no say no. Na obia enhwe na baby we develop dada no. And na omo emfa.
Yes.
At the time no more develop be 50 acres, right?
And so asem na nko Trasu. Trasu because this is how it works. The judgment said Topkins.
Yes.
You are entitled on joint ventures. What do you 62? So you are limited. You are limited. Inti assuming you are limited 62. What de ni nyina ka bomu a. Aban what de your friend is saying 140. You are also limited. Inti by extension balance na one there because Kai said meba obi.
Yeah, but the court did not state that categorically. Is there inference now who you?
Yes, so even Supreme Court used that word. Yes, Supreme Court, and then the Supreme Court cancel it. It's good. It's good. Obi, the word you use, no, is inference. Yes. Supreme Court use that word, but the Supreme Court says this inference is wrong. Okay. Page 5 of this in Supreme Court, or more analyzing page 5. I'm going to say, by inference, the judgment provided that the plaintiff, the first defendant, the third co-defendant, and fourth co-defendant should retain possession of the respective portions of the disputed land that they had already developed or were in the process of developing when the trial court visited the locus in co, blah blah blah. And so they use that word. So it be simple, they say, Oba court in Kratani Nini, we say, oh, there 62 from High Court, Court of Appeal, Supreme Court, say maybe 62. Now say na your course here the headquarters. So I feel who say case ninya no. And I say, oh, me kranami or other document. As some Topkins can me say who's HR. Okay, CID boss say, oh, me kranami or other documents. But okay, so Obi, you've gotten used to the principle of Henderson and Henderson. And then now by court, one for Nina. Obe catch the court says 62 acres. And only 80 to the end. SNF ye case nevia. We see what name or other documents. So until her crown and CID boss say, oh, they say, but one fan call. I know one farmer court. I know. So Obi, this is the judgment throughout 62. So how can you now come after this and then you are entering the area? Assassin I see a bind here. A bind Eddie Biama Nungua, Nungua Diama, we've paid for no, and I bind say, yeah. So how can Topkins go? I don't know, near bind the Maya. Oh, Nane Jam for 15 December 2010, 57 acres. Then you see the your friends and Nungua stool, and so they know. Say, no, may you that. So these two put together, I get 114. A 100 soldier for the Kuguno.
Into maybe after following Supreme Court ruling, Moko Adenta High Court.
Yes.
Na relief ben na musiki from Adenta.
Yes, say person award you because now mo high to say see I dey soldier for Major General Pompi Pride soldier for any Major General AEC e dey soldier for ku go on. That's it. Until on say when you are suffering like that, obeka say oh any yan court in kwhwe e bia ye betime explain. Yeah, you because you have to do something.
Yeah, but the court after listening to my argument, they still a ruled against you.
Yes, and what does it do? Does it cancel the Supreme Court judgment? No. Does it cancel the Court of Appeal judgment? No. Does it cancel High Court? No. Or say, oh, Massa, say the same way into Obi one word, a trace, and can no create juma all this, and there will be no problem. On say, oh my, he need to have the first time. Or say, Ghana no cray and dino cray and nitina. Yet he has a gay and dino cry. Obi, listen, there is no problem. Ye dino cray. Nungwastu signature le boy. Nungwastu signature ni. Inti wo say ye de say oji assassin. Who signature? He Obi nya ni. On hine ni. Nungwastu signature ni. Enu ni. Aban say, Justice Brobe in the High Court, sitting in the High Court, say,
yes.
Government, you have 114 acres. Aban say, okay, so that was 2003. 2010, Aban the assassin man Nungwa, Ebia Kudi Nungwa, Nungwa is turned back and giving it to Empire. Signature Negu, ain't we who saying here court say on your dear. Massa, what jiska na wanje? What sign it? Say, being crowd was SMB, Ichire Muko Rezi Bibi to say, and Empire in TNV, or they even granted. Law, the law is also very clear. Say, so BG was as no in TNV crack. Obesamano, untimin assassins to giddy say OJ. Even assume some make a canning, I just preempt because Matibi, intimate penny, I bet to say, oh, may can ye them at a point until beside me buy mu first, no. I say, oh, what's your Omodoka? I hear sense a man to be beer, but assuming it is true, maybe a nipana no cano, maybe on kaya. Yes, say a banner sana, fasem no court, who beside land lawyer near you. Even Justice Brobe can was a case you. Okay, he put in that principle. Say also what they will to assassin no in Chiaka. Court. O court now we didn't kunim no in Chiasa. Assassin say, no na opa. You can go and take it and sell. This time you will sell. You are not just going to, okay, if you say you want to be given the same land, that's another thing. But the main principle, they say, Nipano, hey, Obi, the principle is that, say, Oma 1 CD, one say Sika, until the 1 CD in Cryant, Yamra 1 peso, say Sika. Once a Ghana, a bang say Sika, yeah, the 1 peso amount, until maybe 2 assassin, ye dear no $1 million. Now Obi may say, oh, Obi ne me hunya cry until the 1 peso, Usoma, once it's legal tender, Massa, Ochina. Se mintimi fan kae ma untimi nkoye just say osamami and I say so there's the one you can try on practical grounds. Say example now you say 1 peso there ebi Martin say 1 peso there o de jiwade ebi ameso nyansa meje ba se manjia because beka say Martin 1 peso away me the court anti uba bitua lawyer ka abetwe manso so it doesn't make sense. So we can talk to each other say master kakre with you idea. It doesn't make sense for us to go to court. So on practical grounds, no, what they may say. But if I can say on just how they no court.
But the other thing and so and because the very recent ruling from the court will be the Adenta High Court on this particular subject. For the purpose of more 8 years, you know. The ruling from the Adenta High Court will say application on notice to strike out the statement of claim and dismiss plaintiff's action CI 47 Order 11 Rule 18(1)D and under the inherent jurisdiction of the court as well as by the rule in Henderson versus Henderson. By plaintiff's writ of summons and statement of claim filed at the registry of this court on the 3rd day of June 2021, it claims against the defendant for the reliefs of and a hanona plaintiff no namoko Adenta High Court declaration of title to all that piece of parcel of land known as site for Empire Builders Limited situate at Borteman in the Tema Municipal Assembly District of Greater Accra region of the Republic of Ghana. The boundary whereof commencing at a pillar marked into pillar ne mark ewaha, which pillar marks the southeastern corner of the piece of parcel blah 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 into oma size of land no any bibia ewaha and say point of commencement that's containing an area of 62.466 acres or 25.80 hectares more or less, which said piece of parcel of land is more particularly described and delineated on the plan attached thereon. and mo sign call make a claim of recovery of possession. Mo make a claim for damages for trespass and order of perpetual injunction restraining the defendant, its agents, workmen, blah 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 from going onto the land. Mo call for cost including council's fees, such further or other reliefs as this honorable court may deem fit. And really not say the defendant applicant has entered a conditional appearance and has subsequently filed a motion praying this court to strike out the statement of claim and to dismiss the action premised on Order 11 Rule 18(1)D of the High Court Civil Procedure Rules, that's CI 47, which reads the court may at here to make things clearer. To make things clear.
They just cancel the case. Supreme Court so live within it.
No, but the point is that says Supreme Court why did you still take those same reliefs?
Pressure. Is the easiest question to answer. Like as I'm saying right now, soldier for show me phone.
No, that be my point. You can go to court.
Obi, that one that's the easiest answer. Obi, look at my phone. There are soldiers there.
No, I agree. The American say
so that one.
If there are soldiers on the land, yes, we've shown those videos. Our Muputi some way from you possessing the land. You don't go to court on the same reliefs how they call High Court.
Law. Mistakes happen. Obi.
But how can that be a mistake?
Hospital doctors mistakes, patients who die. Mistakes happen. I bet you me lawyer or Ghana or court or because say
no, but you cannot make a mistake on the 5 or 6 reliefs out in the court. How can that be a mistake?
Hey, Obi, did I hear say, oh yeah, LLB? And
no,
yeah, so I want to slow down.
I'm saying we have question. I'm not making a value judgment.
Mistakes happen. It's a very slippery road.
Okay, you are saying, sir, the entire statement of claim I'm what they call Adenta High Court. No, a mistake. Is that your argument?
But Obi, that's what the court says. So who are you? The court, yes. Court no say Supreme Court akase wie. So the main thing say ntina make say yen stop you. Lawyer the asem na kokko me nka say of course I wasn't the lawyer at the time. That's not to say me so me mistakes ni be da me radio so me ba me can because I na man for you at times people think say okasa radio so say court case they won't lose be that. No, Obi there's no lawyer in Ghana. It's normal idea. Say see am no kase Obi say we me fo okra ka say mo yi.
No, we show those videos.
So the fugu assassin so master why do you bomu? Lawyer, obey mistake. Patients, Kpebu or hospital.
Counsel, but a lawyer
cannot be explaining my colleague's mistake. I also make mistakes. What am I going to say? It's a mistake. Court say, Master, don't come back here. Supreme Court TV, and I'm say, so mind him, not her. I like the topic, and I'm can. Obi, we are here because your ethics, no, your principles, now, sir. Yen cannot correct. Obi say what kind judgment 62 acres from High Court to Supreme Court. Top Kings we say what dey 62 one we joint venture company. Inti other Top Kings baby bisa no say openyi with 62 no money aba na because before we get to this I say Top Kings lawyer you call CID no my friend lawyer may give me phone na kire again. Yes yen ko susu say yaba 62 no na omontimi nka da say yaba 62 no but for the avoidance of that, yes, Yanko Susubio, kwa messages, Top Kings lawyer. Yeah, quite my friend who say, yes, surveyor, are you ready?
My point will be, sir, granted, sir, Adenta High Court was a mistake. You had the opportunity to go to the appeals court, file for a relist of that, and also the court is striking it out.
And why lawyer Obiana make say honey there. So the lawyer say say you nyina etimi ba ne say sumie ma adwen nti ne High Court ebu asem no Adenta High Court office o de judge no wanti ase o kwa appeal it asi da utimi file appeal say do appeal no sa no we dwane o say we there o kwa sutura obeju no nyese yembo wasumba wa utimi say appeal we ampa judge no ne o kan no High Court no say circuit court district court o utimi say ne judge ne kan ne nyansa wo munti appeal no wa twe assign. It happens. Obi, it happens. Into our lawyers who bet win some, lose some. Win some, lose some.
In the Siciano, are you going back to court? Because that looks like the only possible thing you can do.
Looking at it, that's just what will have to happen.
And say more court this time now. What will be your claims? Say more call for further interpretation on what the Supreme Court said. Because there is a dispute on that.
Strategy. So that one I can't. We are still looking at it. we are still looking at how to couch it because I also know and now okay actually and then so so we are still doing pros and cons of each method, whether you go for clarification okay or go for the enforcement judgment plan those but Obi may catch it up. So I thank God that if you read all of them and can no create Juma, it will be there is no issue here. Nungwa signature ni baby as a soldier funuguna assassin then I've shown you the government one. So mobile man fan material bind at times no
sir I bind the enemy Nungwa all of them were if I was a catcher or say Initially, the contention was assassinate a teshi for there. The court settled it, say a nungwa for assassin, but if a nungwa for when you be ma teshi for when you go back into history. In the end, there is no contention on that as to who owns the land.
No, baby a soldier Fujina Sisiano. I buying a demand, if you are buying a
or the man nungwa for as nungwa for the
amount. There be a casa buying yes, I buy the kanji free
nungwa for
1940.
Sure.
And the children who say I buy a Jiwasas known to me, you see on farm mount. So I buy a lease back. It's not even outright or lease a lease.
Okay.
More 900 and something and they for 1,000 no. Right?
Yes.
And then Kakrana Akano. A move 57 and I bind their mind. So that 57 nungwa is not challenge. Yeah, crash. Obiete yani nungwa fine. Oh, Trasacco koso hini only nungwa fine. And I saw Tarikun only nungwa fine. I send bien ni ho. Yani nungwa fine.
But when him say nungwa, meaning so one who nungwa for one statement no more issue. Now have you seen it?
Oh, sometimes those things happen. I mean, which one? I've seen some in the past.
Okay.
But from time to time, a press conference.
Was it a press conference?
Yes.
It was sent to me. Maybe I'm a share.
Yes.
Me who and then for now boy you now won't come on.
Today.
And the 30th. Okay, there is one on 30th August 2022.
Yeah.
Press statement by the Nungwa Stool concerning ownership of land situated at Trasacco Enclave. Almost after 21 years of protracted litigation between Empire Builders versus Top Kings Enterprise and 4 others, the Supreme Court, the highest court in Ghana, entered judgment in favor of Top Kings and its grantors, the Nungwa Stool. The Supreme Court adjudged the Nungwa Stool to be the true owners of the land described as situate at Adenta North, Accra, comprising an approximate area of 465 acres, and Empire Builders acquired no interest whatsoever in the land known as Trasacco Enclave. After judgment was delivered against Empire Builders by the Supreme Court, the owners of Empire Builders, namely Ernesto Tariconi and Morris Ian, being disgruntled by the decision of the Supreme Court, have taken matters into their own hand to disrupt the peaceful enjoyment of the judgment by the Nungwa Stool and Top Kings Enterprise Limited, in clear breach of the decision of the apex court of this country. The above named persons started by petitioning the Ghana police with fabricated stories as to the ownership of the land. During investigations by Ghana police, the police became aware of the Supreme Court decision and accepted and granted to provide security to the Nungwa Stool to take possession of the land. To affirm the ownership of the Nungwa Stool and Top Kings Enterprise Limited, the Attorney General, who is the principal legal advisor of the government, wrote to the Inspector General of Police and directed him to desist from interfering with Nungwa Stool and Top Kings' quiet enjoyment of the land. After exhausting possible avenues available to them, the owners of Empire Builders Limited, particularly Ernesto Tariconi and Morris Ian, have resorted to illegal means such as the use of land guards and armed men to disturb the quiet and peaceful enjoyment of the land by Top Kings Enterprise Limited. One such incident occurred on 21st of March 2021 at the ungodly hour of 1 a.m. when Ernesto Tariconi and Morris Ian sent armed men illegally onto the land and beat up the site supervisors placed on the land by the leadership of the Nungwa Stool and the management of Top King, and then went ahead to demolish the fence walls on the land. In light of their, in the blah blah blah, have finally said, we are therefore by this joint press statement calling on all security agencies in the country together with the media to assist in upholding the peace and the judicial integrity of our country by ensuring that all persons found acting in contempt of the judgment of the Supreme Court is held accountable and made to face the strictest of sanctions. This is signed by Oboa de Noche, Ken, Prof. Odaifio Welenchi III, Nungwa Manche, Ena War Lumo, kono nungwa bibi bichuru babu wulomo enti omo mienu na assign clearly omo story as a boy bro na
but obi judgment in there die so that thing is and I'm like nungwa fine so let's just put it politely. A lot of inaccuracies in it. Obi say judgment no nie. Obi won so working can be. When who say yakasi nungwa kwaji wasase. The last time something was mentioned about nungwa directly no. Justice Brobe said debi nungwa too. Pacho untimi nji wasase. Also untimi nji. And that's why I stay. And Obi apart from Justice Brobe saying so say you know almost signed 1999 the memorandum okay and now you see it in the judgment so 2006 you could confirmatory grant you could tuye and then you see this 2010 one 62 acres yeah sikadia da Trasacco tuye sikasa empire tuye sikasa sentina ye nungo eni asem so Obi putting it plainly sometimes Sani me na yakase okay you na pay bibi man penyufo that's the thing that is supposed to be but e chire no na right say yenya we on free her where we say na me say chia top kings or kase we are foreigner they say e bi onim say Trasacco ye nesu ye Ghana ni nema ye Ghana you see them have cars only Ghana ni worry ye you see ntia ha not ne papa wa ha oba ha he was a young man. Okay, all those from 60s. What now, sir? All the Nikrum ni Nema Ghana for ya war.
Yeah, that is not in doubt.
But that's what you were saying. So they made in the root cause. They say one of them say, "Ah, I say we free Krum, we free Italy. The other engine free no ho." And look, that's the you could see idea. Obeti say me say say, "Ah, we free Italy." And I'm obeke bi amano. We free Italy. And I'm obeke be. Yes, sir. A man funti mimba investi wa ha. America. It's a great nation because it's welcome people. America is where it is because it welcomes people. So America for be a Britain for mutuko America, Irish for mutuko. Say America na red Indians never ho.
Sure.
Say you British. Say come your friend is famine.
Yes.
I come na di be quiet. Been no we religious pilgrims. Abra na Roman Catholic Church or ne Anglican team no.
Yes.
And now Queen now ba no how mo or titi or mo no so they be any be sorry free. No mo sorry free Britain ho. Echo Netherlands from Netherlands no mo kwa America. So some are religious pilgrims. It been so called for business, slave trading. Into share American ne. Look at how great it is. Obia ko ye juma ho. Into sa assassin sign thankfully we assassin 114 acres near ko muti say assassin asan Ghana. Oh they be. So those things say free Italy mo mi enjoy enye. E chere say Ghana fo indum ni bank or
US.
Ghana fo penny Dr. Kofi Amuani o mo ni businesses for US. Nti sa de me enjoy ka Obi me say asemba kwa me ka say Obi me mpesa adiwe odi be ka akwa another lawyer no aka say Kpebu na oka say Kpebu nim huti as far as I'm aware at least we dey metiase kakra metiase pa you Obi you read the judgment you don't see anywhere Supreme Court say hey any you nungwa monkoji assassin free so
yeah baba and no shouldn't we because I recall from reading Supreme Court judgment so and I'll refer you to page 6 of the judgment and on I can appeal before the Court of Appeal. Dissatisfied with the judgment of the trial court, the plaintiff by a notice of appeal filed pursuant to leave granted on 17th May 2006 mounted a challenge against same. The grounds of appeal set out in the said notice are as follows. And grounds of appeal no are very important. A. The trial judge erred in dismissing the plaintiff's claim on the ground that the plaintiff lacked capacity under Article 2264 of the Constitution to hold the lease in issue. The trial judge erred in not referring to the Supreme Court the interpretation of Article 2664 of the 1992 Constitution and its applicability to the plaintiff company. The learned trial judge erred in entertaining the issue of capacity of the plaintiff to hold the assignment, which issue was not properly raised for determination. Good. The trial proceeded on the wrong principles of the burden of proof, thus disabling a proper assessment of the plaintiff's case. The judgment is inconsistent and illogical in that having pronounced void the plaintiff's leasehold interest on constitutional grounds, it nevertheless upheld the plaintiff's possessory right to part of the property. The learned trial judge erred in dismissing the plaintiff's claim on the ground that part of the disputed land had been acquired by the government of Ghana. It means in the High Court, the point said government of Ghana acquired part of the land and it was dismissed, right?
There was a point saying.
So the learned, because one of the grounds for more appeal, then they say the learned trial judge erred in dismissing the plaintiff's claim on the ground that part of the disputed land had been acquired by the government of Ghana. The High Court dismissed that claim. Good.
Yes.
The trial judge erred in not upholding the plaintiff appellant plea that the third co-defendant respondent was guilty of laches, blah blah blah, any acquiescence, any other, and judgment of the Court of Appeal, on the point number F, which is the government of Ghana acquiring portion of the land, almost say, let me see, the third defendant, okay, it's not that one. Since the appellant failed to amend its reliefs by the inclusion of a relief for possession after it had obtained leave to do so, the leave granted thus became, okay, that's what you've read. But on the bit about okay, let me see. Even though registration constitute notice to the whole world, registration per se, the appeals court ruling on say government of Ghana acquire part of the land, said earlier, what the appeals court said about that, because now a part of more grounds for the appeal.
Appeal court said there be any case. Say no yajitum. Appeal court say any case. Government acquired it, and it's true. We don't fight it now. Say intina me say government obi na echire say yajitum intina yeko aban ho na 2010 na eje ampo for that time he was chairman of Lands Commission. He's still alive. On no sign here. And Ojina Aban and Omode Mai 57 acres. And then the other one 62 no. And now Omode Mai Nungwa as part of the 1,000 acres no. And Nungwa de mine. So we don't dispute it. You are allowed to compromise a judgment. Wako court we dinkunim obie dinkuku. Mrama okwan say why we dinkunim no obetimi aton ama no. Say okay minia me do ashifom. I've won in court but the tuaka meji will say J. Yeah, so we've taken it. We don't dispute. So I make an so ask them, say, have they challenged this government? And then look at Nungwas too. And only signatures. So Obi does that, it's a simple matter. You can't create this.
But Sisiana more sad document where say signatures ni bibia wo hoyi. Nungwas too, so say. In fact, and you heard the statement I read from them. What would you do? Because you see, I know they claim says our document we are more shown near the Adina.
Oh, there be and say at times on say negotiation. Nipane pese will negotiate here to make sure say minimum menton be biama menton and no. That's the kind of statement. So at times oko negotiation ultimately can't say be a bia. But want to retreat say you nungwa fine. Money on me fine. Nti adia top kings kayiti abum ye enye yenungwa fine. Topkins ye panochara he should stay within 62 acres. Ye there ma ho and am yi me phone chere ma frafre lawyer sa say yen konku susu say me ye natural.
Yeah, but unim say and I love the bit about money nungwa in common, but my curiosity now would be say if you look at the appeals court ruling which is referenced by the Supreme Court. And if you may, turn it to page 9. Page 9. Okay, maybe 1 second. Page 9, yes. Page 9. Very, very important to put all of this in perspective. Page 9, Eka said.
Page 9 of the Court of Appeal.
No, the Supreme Court ruling, no, page 9.
Okay. Yes. 9.
Page 9 of the Supreme Court ruling. In the account of point number O, the evidence on record shows that the plaintiff later got to know that the land it occupied belonged to the Nungwas tool and not the Teshi's tool. And that was why, when it was challenged by the defendant, it approached the Nungwas tool to sign the Memorandum of Understanding to regularize its occupation of the land. The memorandum per se is not a deed of conveyance. It also explains why in the second suit, Atema, the plaintiff claimed ownership of the land as a grantee of the Nungwas too.
Excellent.
The evidence on record clearly established that when the plaintiff sought to regularize its grant with the Nungwas tool, that tool had already leased the disputed land to the first defendant, and therefore the Nungwas tool had no interest in the land to lease to the plaintiff except a reversionary interest. That shows the document I see how Obandi say the money Nungwas tool na sign. It's probably of dubious validity, no?
They be near no. Intinio Mokano, so say memorandum. Memorandum is 1999. It's an old one. So we're 2010. We're after High Court. In your way, no more can asem. They be a full year 2010. Debbie, that's not what they are. There's a MOU. Let me see if I can get it for you. That also offer. I don't know. Very good. So let's use common English. So Omokato say memorandum.
Yes.
The document. Where the memorandum? The assignment, deed of assignment. So it's not this one they are talking about. And I bind the deed of lease. It's not. That's not it. The memo is different. I'll find it for you. So deed of
no, but if you hear what the appeals court
it's there. Yes. So I told you that 1999 you call Nungwasu. So you see, this one is called deed of lease. This lease is made this 15th day of December in the year of our Lord 2010, and then the Nungwa one, that's the 114. I have lots of documents. Maybe we can go to another question. I'll get it out. 1999. So I make us say, assassin, you kasa 3 times. You kasa 3 times. So yes, we accept that 1999. See, who say a san kofa. Who said they be where we bought it from the we had to go to Nungwa. Yes, 79. You know, we are fine.
Yeah, but mo call Nungwa. No, me bow. But mo call back to Nungwa. The Court of Appeal says, Nungwa at the time had no interest to give you any land.
Yes, they are talking about Topkins 62, no?
No, but that is not stated. You know,
because this is how we do it. So ask yourself quickly. Topkins back court, or say, almost say for the first time, or say, 62 year media, and now page 9, Topkins, or say, where is it? For the first time, say you can do it. Which paragraph for that? Okay, Obi. I say for the first time in this
amendment, counter claim, no?
Yes, I'm buy, for the first time, I don't 62 na year deal. Say you can do it earlier on. For the first time. The announcer say, 62 na year dear.
Yeah, but sir, they would have said 62 because again, as part of my reliefs, no, now mo relief say or my trespassing. And as I see at the time, no, my costu AC dying or so was the 62 acres. No, did they will say so, no?
Yes, and to I say 62 na year and that's what Justice Brobe gave. Or say the 8 acres, the 22 acres, and the 32. That's the 62. So that's it. I know there that's it. And I'm catch say you can see I do nature opinion or say Chabeka say, no other documents. And I say, opinion, even CID boss catch Reno, Madam Fosinando Kofi.
Yes.
I say, so a lawyer. And Madam catch say, now the chair court. That's it, they be. That's the collapse of your case. On the chair court.
Yeah, but no, was it a counter claim and I say no your response to Momo?
Almost statement of defense.
Almost statement of defense.
Yes, but there is law say, Obi be challenge you say 465 and I 456 year media.
Sure.
Back quarter also media made the 62 pay. And I caught Buya 62 now. After 20 something years, now I say, say now me wakrate bi kan me refi man fan kan David.
Yeah, but see the dispute now. They say they also court Ebua 62 among no they disagree.
How do disagree? I him fan could disagree. Supreme Court. No,
they've been granted.
However, by an amendment, it effected in its defense.
Yes.
You see, even amendment to into first defense. Can say a trainer who say, "Hey, Charlie, I'm sorry." I say, however, by an amendment, it effected in its defense to the action.
Yes.
The first defendant averred for the first time. That is on back court first time. Krano into me and cast me 62. A trainer. Who say, I dear Coboni until the men say 62.
No, but maybe and no yet the 62 no is not what you sent to court. The reliefs the whole thing. Because the court gave ruling based on the whole thing now.
Yes, and our court said the reason we did the whole thing was that almost 62 like octopus. Omonsa will be octopus. And she say, hey, you want crater for 456. And he said, okay, 62 over be massa baha no massa and then don't forget
in crater for 456 no the court did not grant you that
yes but they gave us the rest. That's the 278 Justice Brobe say to avoid confusion, it is important to clarify the portion of the disputed land where the plaintiff's claim for possession failed. Obi, I want to use this phrase. It's not all or nothing. No, they be caught here. It's not you either win all or nothing. No, I must say what about for 456? But I tell say opinion will say the companies normally 62. I buy say you can animal husbandry and road. And I may say 114, but people are not challenging the calculations. So we say 114. I buy so the rest that's for empire builders. The rest is for empire builders. So if you go to court of appeal, say
but how the rest is for empire builders, it is not stated in the ruling.
It's stated there. It's here. Everybody and even Supreme Court.
Yeah, everybody should keep what they have developed.
And even the Supreme
Court. At the time, no more develop 50 something acres. No. At the time, you have developed only 50 acres. If everybody should keep what they have developed there. It should be 50 acres.
You are developing, not just developing. Also, ING. About 200 more. Okay, Obi, it's good. The more you ask, we will repeat. So I'm out for better. You are good. It's good. I'm now getting it. So fine. And I kind of once I ain't about with the repetition. Obi, that they have already developed. Or we're in the process of developing. Page 6. Obi, and I get it. At times that you refute these rules of journalism. 5 under to 6 stop. Or see, developed or we're in the process.
Yes.
No.
But in the process of
if it was wrong, you didn't come court of appeal, you didn't come for injunction. Supreme Court, you didn't come for injunction. Why you didn't you didn't challenge government of Ghana. Bisa Topkins said, court, and you can't say 114. Animal husbandry, you are buying the road, you are buying the challenge, you are buying. Challenge, as you read in this judgment, Court of Appeal, Supreme Court, what he said, Topkins said, hey, assassin, I had my buying, and you are buying the. Did you see them challenging?
Yeah, but some Court of Appeal ruling now.
Yeah, because we are dissatisfied.
Yeah, but even on the bit about say buying assign the assassin ma nungwa for ne back and a nungwa for ne dia mamono. The Court of Appeal does not seem to support that point.
No, that's not why it's covered there. They will show me. No. The Court of Appeal is not dealing. Hey, sir, I bind the they be down there. It's a salutary principle. Yan can achieve more. I say, hey, I deal BIG to say, hey, what court no dinkunim? Yes, I dear, oh dear. And Rama or can say, Opa, Nipana, we dinkuko. What me the channel?
Sure.
Opa cried to me say, okay, one person the chance. Okay, master, oh, they assassinate 200 acres. Measure 1 cedi. 1 cedi for your packet.
Yeah, but court ne say, Mumu claim say nungwa for the assassin mamono. And you no cre.
There be any
court ne say nungwa for any right be somebody assassin be mamo.
And your more can any 62 no. 62 no pet. 62.
Yeah, but show me BB say 62 no. But at least the appeals court ruling they say the evidence on record clearly established that when the plaintiff sought to regularize its grant with the Nungwa's tool, and you've admitted say during the pendency of the case from High Court to Appeals Court mo call back to Nungwa's tool to try to regularize and the court they say the you seeking to regularize your grant with the Nungwa's tool, that tool had already leased the land. The disputed land near 456. I'm what they call court. The stool had already leased that disputed land to the first defendant. The first defendant in this case, Topkins, and therefore the Nungwa's tool had no interest in the land to lease to the plaintiff except a reversionary interest.
Okay, Obi, it's not all of that 456 that was leased to Topkins. So I will read again.
Yeah, but what was the disputed land?
It's the 62 ninety.
No.
That was the main. So
in your statement of claim that the land in dispute was 456.
Yes, when I say yes, that's correct because you say apart from that, on bit me atre into your patch say yen crata say we are entitled to 456. Into brabetre.
Absolutely. So that's the disputed land. And the Court of Appeal say the disputed land had already been leased to the first defendant. In the Nungrafon Timin town.
They but or say Topkins said or say for the first time. They said the first defendant averred for the first time its interest in 62 acres of the disputed land.
Yeah,
that is it.
Yeah, but the Court of Appeal saw this.
Obtained from the Nungwas tool, which it registered in 1999. That's it. This Supreme Court too. The Supreme Court.
Yeah, but the Supreme Court only affirmed the ruling of the Court of Appeal.
And Supreme Court now a mistake. What was that?
No mistake. That
62. Oh, David. Nungwana, it's too late in the day. I say 62 acres. And I'm making audio. No, me say, I no penny. Oh, say, hey, I do way when him say, Empire Baby, yeah, no. Oh, can obey. And can 62 now? Can obi me? Mean do be a name say young conquer Hanover 62 because 62 there a happy fee.
Okay, lawyer, into litigation must come to an end at a point. CCR from where we sit, in Nayepe Asumji, Asemna Kwakwa could do Supreme Court. Supreme Court am a ruling. There seemed still to be a dispute on the Supreme Court ruling. Or client did not exercise their right to want to go for a review. They instead based on said your work and pressure almost they try to use the Adenta High Court. For now, what will happen? Because legitimately so, Topkins can say, per my understanding of this ruling, and at least if the Supreme Court indeed affirmed the Court of Appeal ruling, the Court of Appeal ruling affirmed indeed say Nungwas to Lalizi assassinating the entire disputed land at the Amami. Based on that, in Kwan, I have access to the land. In the Ombetima assassination, so what are you going to do?
So there are other measures, and I'm kind, but one say, and I'm a legal strategy, Mimpesa Mekawaha, in the Moma space Katra, and Chibi Albeti Honka.
But Enquayan Tokwa Gidi
David, any Tokwa, and they say a soldier for the Baho, or more higher side.
No, there's a soldier for we are officers of the state. If there is a dispute on any land, don't bet about to come in.
Soldier for me, master, internal peace, a police for and now Yanka Bibi. And now a friend say, opinion say, now watching IGP, I know see Bonnie, so all insinuate say IGP dampering a buy into a Trasacco Hondi and our empire now. Oh, they be near power with the IGP. No, or we say, me, I IGP sometimes I criticize him, but we oh, now me Raho, no, IGP.
But not in the point back on the say, not in the point back on the say, and I know say Ebia Wehu. The legal department of the Ghana Police Service, Emma legal opinion after the Supreme Court ruling to the then IGP. In fact, that legal opinion came from COP Kofi Boakye as head of legal. And that legal opinion said, say, your friend is saying, Topkins and go ahead, no mun develop on Masasa, like Omanyomo ruling from the Supreme Court. And they went there, took possession of the land, almost started to develop it until say, change in IGP by and the new IGP in the by, new master society, and it's legitimate so be raises our concern.
Dr. Dampare, so no when mistakes happen. Obi. Oh, judgment mean mistakes happen. Tina make say Nadia. Mistakes come man for mistakes be bria. Don't forget.
No, but mistake is such a crucial issue there. So
mistakes there. Now when be say Attorney General. Say now can Attorney General letter no. Attorney General can I say High Court say everybody should keep possession of what they have. Do you see?
Yeah, but that will be your 50%. If you want to go on that route, then what you have would have been 50%.
No, 50, I said developed or developing. We're in the process
of develop, but you cannot develop a land you don't have.
We're in the process.
But lawyer, you cannot develop a land that you don't have.
No, it's ours. And look, Obi, thank God.
The Court of Appeal says it is not yours.
No. Court of Appeal didn't say so.
But I've read it to you. You've not disproved it.
No, you don't understand. That's what I said. The Court of Appeal didn't say we should get off the land and come back. Almost say order no. So we have different types of possession in law. Into a say decree in a paper no me and mine. But what is our case sorry free so into your fiscal possession and now order no can that's a decree court paper no say amount court paper but you can be in fiscal possession.
No, but your point
different
you were going to develop the rest of the land because you had acquired it from the Nungwas too. That's a point you've made. the Court of Appeal, having been seized with all this, said,
no, we was not seized with these two leases. And our leases will be and Tokwani say 114 in any Court of Appeal in him. So as you are talking,
the Court of Appeal says, the land in dispute, 456.
Yes.
All those lands now have been leased by the Nungwas to the first defendant. Right here.
But no, that's not the meaning of no. That's not what they call it. Read it. The
evidence on record. No. Remember, the evidence on record clearly established that when the plaintiff sought to regularize its grant with the Nungwas tool, which Adiawa admitted to, that tool had already leased the disputed land to the first defendant. What is the disputed land?
Good. That's how I told you that. So you are correct sometimes when you say the disputed land is all of the 400.
Absolutely.
You are right.
Absolutely.
But there's also there's an other meaning of it, which is the 62. Because when you appeal, say, 62 no more demand Topkins so you need because that time bro be say
and that number person mo kwaji 62
yes and that so Obi understand that point so anointing at top empire akwa appeal no that is the main thing. That is it because bro be say
but appeal be amobeko be as na court na boy
I see there be 62 there were lie obua Topkins there we are G2 say finally we've gone to the end. Hey, Debbie.
Okay, no, I said the work cannot say more legal strategy and no the one person will divulge this information
because
we'll see how things will pan out.
Yes,
in for now, no.
Yes, soldier for no internal peace and security in your juma until police for me into 100 there.
Yes, I said do maybe a police for me and
IGP dampare obet me pa otimi na IGP on say CID boss for Sinando Kofi. No bohu by she was dealing with the
but they've been cited in the contempt.
Say ni bia no. Because na omo high was assassin so but Ando Kofi Faustina she's a lawyer she can read so can and I say look Obi we dey nani ya be keni nyina yen jantu nche ni bisa say we next time for bar Topkins ni ya abain the sign a crata lawyer na Nigeria ample for goso ex goso oman hin
okay
on no lands commission chairman on no sign the signature we so nungwa ahemfo no na sign ye 114 acres nungwa no de mai bibia se sia soldier for ni Topkins say high 114 ni abain say sorry court say abain dia abain dia ma the fan ama nungwa dia man the rest 57 acres abain dia ka ho man 114 why send the soldier for back
baba eno no na make us sia no say omonso because on the face of it if I pick the Court of Appeal ruling which the Supreme Court affirmed na me kind sa part na me kind ma una I would think say I have legitimate way to
and tesa ni ya explain sa
and that's the explanation maybe we need to get the court to clarify that bit once and for all because I say obia kan and understand
the Supreme Court page 27 another thing we'll not forget page 27 Supreme Court said for the first time is the first defender averred for the first time its interest in 62 acres of the disputed land it had obtained from the Nungwas tool. Tiababe now 456 or 465. Obaya first time went me and can ye into the amendment and now they buy I feel so there be 456 maybe 62 per and our Supreme Court page 27 paragraph 38.
Yeah, but Supreme Court and
62.
Yeah, but so be kind Supreme Court final decision. Paragraph 53 and 54. Upon our review of the entire record of appeal and having duly considered the submissions of both counsel, we are not persuaded that the findings and conclusions reached by the Court of Appeal in its judgment dated 18 December 2014 warrant any interference by this court. On the contrary, we are in agreement with the findings, reasons, and conclusions arrived by the Court of Appeal. We are of the view that both lower courts correctly applied the principles of evaluating the evidence and attached the correct probative value to the evidence adduced in relation to the party who carried the statutory burden of proof. And part of the Court of Appeal judgment and amekai edemawa asaseno nipa or rightful owner of the land and I will say but the Supreme Court affirmed that decision of the Court of Appeal.
Yes, and the Court of Appeal. Did you see? And I say, maybe I can say 456. So Topkins has never said 456 is for them. They've never said any because I buying crowd in your mood.
Yeah, but Empire Builders has said, they own interest in the entire 456.
Yes,
and the Court of Appeal says no, that's not true.
No, the court said, Justice Brobe said that no, you 62 in Tunche, and then you animal husbandry and road, which is equivalent to 114 in Tunche. The rest is for Empire. Then we went on it. So Kai said, who went on appeal? Another way of finding who appealed? Who appealed?
It is you, Empire Builders.
Yes. And they say Topkins 62. And yeah, they say almost say 114 ya bind there. Internet just say Topkins here, Omunya 62. No, they were happy. Oh boy, say say Nishre. They were happy see Enya 62.
They were happy because at the end of the day, if you go to court, say court in declare title for what? It is based on Adia Unajinaso. Adia Unajinaso ne say ma acquire land no from Nungwa's tour.
Baby, you so later on, and no, you will go in circles, but bottom line, later we saw it was wrong. High Court, Bisa, High Court, Nungwa, did they even say they should collect back one plot? Judgment, one plot, guys, the court looked at all of that and saw that we've given Nungwa money.
But when the court says,
we've given him money,
it is, you cannot build anything on nothing.
No, but
there was nothing.
Okay, so
to
the
start
other
with.
thing too is that look at it. We've read. Have you ever read any of the judgments? Yes, in Nungwa, go and take even one plot. Have you read any of the judgments? And so at least you've seen for Topkins.
Yeah, but by inference, if no, that's not we are inference. If by inference, another lawyer and so say, court ne say Nungwafo ni right cross on beton baby amamo. There was no money interest behind the land to sell anything to you. They had already leased it to the first defendant.
No, it wasn't
what
all
does
of
that
it.
mean?
It was the 62. It was the 62, not all of it. And Justice Brobe, on page 15 of the High Court judgment, I say, remove the 62 for Topkins and his affiliate, remove the 114 for.
But that was not the land in dispute. So that was not the disputed
land. It's a disputed land.
The disputed land, 456.
Yes, and was see 62, Matt Topkins, na brofono, ne 114. That's in other words, here you not see 114, you just see animal husbandry. A trainer, okoye calculations on the ground, you see it, no. But see here, no man. The rest is yours. Then we went on appeal.
That is where maybe the dispute is. Let's see how it goes. I mean, you did sorry,
because you see side, no, that 200 and something. You see a no man for titisono, and no, you can't Supreme Court say they be or monosancroft no man ministers name pennyfuno or man court into your mother don't touch them because they will be answer more. Into 114, what I'm saying now, I know, okay, say 114 now, some abahono. These are the documents. Nunguani abainie 114 na ye de soja fo kugu ho no nungwani abainie ti ye say soja fo
ba nungwani abainie we ne de it is still a subject of huge contention. At least if you read the appeals court ruling, appeals court doesn't touch this document, doesn't touch this. Did you see them say government of Ghana has no right to lease the land to Empire? It's rather said Nungwa's tool has no right to give you any land.
No,
but they had leased it to the first defendant.
Excellent. So let me answer, please. This land was not in the possession of Nungwa at the time. This land was in the possession of government. The first time government gave it out was 2010.
Yeah, but you didn't get it from government, did you?
We got from the 117, the 114. No, it was with Brobe say buying there. Then that's 2003. So it's in 2010 that government was giving some land back to Nungwa, and 62 fell in there. And Nungwa turned and gave us. So that's not what they were talking about. So in other words, no, this land had always been with government until 2010. Good. When did Topkins go to this Nungwa? When did Topkins, didn't they say 1993? Good. So 1993, this 114 was not with Nungwa. Nungwa couldn't have given them. So 1993, Nungwa couldn't have given them because this land 114 was always with government. It was in 2010. Government gave part back to Nungwa, and then Nungwa leased back to Trasacco, and then the other half government gave to Empire directly. That's it. So, be make a choice. I say we won't. Listen, me, I can't be there. Me, dream.
What did you do?
I can't do that.
But look, I appreciate your time on our show. We would get back to you if need be. Why? We'll get back to you if need be. Mema, I think I gave you the Me my court of appeal really no.
Yes,
If
yes,
you may,
Mami.
yeah, na odia mami na.
Thank you.
Okay.
Obi, why are they?
Me that's it. Me that's it. Yeah, at least na nyoma clear am obi atene ho ase.
Oh, say court yeah, time for repetitions. It would be a repeat. I hear now review. Who be say yeah repeat because court and say yeah nimre wo ho. Nti e want to near court but it's good.
Me that's it.
Obi say what you say we hu.
Oh, I think there are still contentious issues. I mean, depending on Nipa,
1993, when they were signing, assuming you are saying it's the whole of the 456 that they were given to Topkins in 1993. At that time, the land was.
It's not assuming. That is what the Court of Appeal said.
No, Obi,
but I just read it.
No, that's not the meaning. The disputed land they are talking about at that time
is what was in your relief.
62. It's no longer the whole of it. It's a 62. Who said? Who went on appeal? No, maybe Obi. Let's settle this logically.
I am not a lawyer. The American say the issues for the court to settle, the fact in issue, any BBI, it is on the 456. That is the first in your statement of claim.
Obi, it's good if asked it. On appeal, it was no longer the 456. At that time, government, Justice Brobe had said everybody should keep what they are keeping. And then the Empire was not happy. And the Empire said, no, 62-year Kura Topkins, that's why we appealed. So you ask yourself, in other words, who appealed? Did you see Topkins appeal? No, they were happy they got 62. And the Empire said, no. We will not allow this 62. We'll go on appeal. And then the government will not allow. So who appealed? That's the way. If Topkins wanted 456, they would have been the one to appeal, say, oh, my lord, no, our land is not 62, it's all of the land. Why did you give Empire?
But lawyer,
they would have appealed. They never appealed.
No.
They never appealed.
If you are going on appeal,
never appeal.
Who call appeal after a tri-quarter, you go on issues of law.
You don't necessarily fact and everything.
No. You don't necessarily
all of them.
You don't necessarily.
No. Obi, please don't go on there. It's both facts and law.
No, maybe.
Okay, say now. Go ahead.
Yeah, maybe. You cannot go to appeals court. Na wakwakofa fresh evidence beer. Na the High Court was not seized with unless under some very strict circumstances. In this,
that's good. It's correct.
That's correct, right? Yes. In this Court of Appeal case, the basis for the appeal, because and uzami trome bo ana me kind basis for Moko Court of Appeal. No, Emma Oka say me repeat it. Baby any I know because I mo grounds for the appeal na. Makaini nyina. Ebi any na mo ka say 62 acres court ne de ma monfo aso baby any was a grounds of appeal ni nyina any there are 1 2 3 4 5 6 7 8 9 10 11 grounds baby any one can about
so that's how we interpret them. They go to the same effect because at that time a year appeal a High Court Justice Brobe has said everybody will be ending the lane, keep what you've developed or you are developing. In TCSA way, a Topkins should keep 62. Near Cassie appeal automatically it's against the 62. Near say a buying keeping animal house boundary. That's why we are appealing against. That's why you see them. Because how can we be appealing against what we have been given already? What we are already holding, we can't be appealing. We say we are not interested in the land the government the court gave us. No.
But the amount of cars and say me kind ground for the appeal now. Baby, and who are more on an issue of fact, only now issues of law. All of them issues of law. Baby, and who are issues of fact, and that grounds my earlier point. Say when you are going to appeal, unless under very strict circumstances,
let me show you where facts are. Okay, I get it. You are there are facts, but there's also law. Sorry, there's law, but there's also facts. Until person who be are facts, listen. Let me Anytime you hear the judgment is against the weight of evidence.
Weight of evidence.
That's facts. Facts. And law. In actual fact, it's mainly facts. But penema with the law even in natural fact when you see some Supreme Court decisions and the judgment is against the weight of evidence say no don't argue law at all. Owusu and Amwa Owusu Domina versus Amwa and then Atuguba and Associates versus Sion partners etc. Almost say facts now which me argue law so that is it. So you see facts. That's facts.
My inference I think we've spent so
yes,
much
you've
time.
done very well. You've done
Thank you.
extremely
Thank you.
well.
I'm
It's
grateful.
been, I've enjoyed the debate.
I'm grateful. I'm grateful.
Yes.
Nyame adoma ya be science what was.
Yes, God bless you.
Thank you so much.
God bless you.
Ekosi sense ni.
But was
that Osan back on bond way, you know.
Thank you.
Why?
Thank
You be say from back on the bond
Perfect,
issues. No, why?
perfect.
Yeah, that's
And
it.
so he should listen, put his feet down and make sure that Furiata pays us. Because yeah, bro, you could get too much on my opinion.
Lawyer Martin Kpebu
Yes, sir.
and I attend and can you see saying Sunni? I accept.